Sir, I know you don't want my representation, but I would advise
No, ma'am. No, ma'am. No, ma'am. No, ma'am.
I would
Please
advise that
don't.
you not
Please
talk
don't.
about anything that happened.
Please don't, ma'am. I appreciate it.
All right, we are on the record in the matter of People versus Latavas Trashad. This is case 25-0203-FY, and may I have appearances for the record, please?
George and Ed on behalf of the people, Your Honor.
Thank you. And
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
okay, and Mr. Thornton, could you state your name for the record, please?
I will object to.
Quick hook. An arraignment is mostly charges, rights, and next date's not a debate. That's why objections don't fly here. If you were in his shoes, would you go solo or accept the public defender just for today?
Let's say back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December. I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn to appeal. You want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
Yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavas Trashad Thornton being a nonprofit organization, and I was just objecting.
Legal check. Competency isn't about guilt or morality, it's whether he understands the process and can help his own defense. If the court doubts that, everything pauses for an evaluation. Should judges default to evaluation when a defendant rejects their own legal identity?
there aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. Now, Mr. Thornton, it is true, you are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So I want to make sure that you get all of your rights and know everything that is available to know about this case, to give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. No, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing.
Name issue decoded. The court must use the legal name on the charging papers, so the record matches the person charged. Also, stand mute means the court enters a not guilty plea to preserve his rights while he reviews the evidence smart safeguard, not a trap.
I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute disrespecting your courtroom? If I speak out of turn, could you just simply let me know? And okay. I am aware that what could, like you said, come back and haunt me. I'm well aware of that for Latavas Trashad Thornton. However, I do still need to express correctly. It doesn't matter now. Why can't we do that? I have more than just the Sixth Amendment right. I have I have a plethora of rights, Constitution and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all the. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless.
Teaching moment. Innocent, unless not until proven guilty matters. Unless means innocence continues. Unless proof clears a very high bar. Tiny word, huge shield. Should judges explain this plainly more often?
Can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Lieutenant Trisha Thornton, for that the script so that we can bring the courts. I'm even here to surrender all of the interests of Lieutenant Trisha Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Lieutenant Trisha Thornton as his representation. That is why that is the only, not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Lieutenant Trisha Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I have the right to let it be known that I'm not the surety. And
when a guy named Mitt Romney was running for president some time ago, and he said, and he really upset people with this. He said, and a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law, but a person does not become an LLC. But regardless, we're accused of police officer assaulting, resisting, and obstructing. And the specific allegation is that on or about March 9th, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did the police department that the defendant knew or had reason to know was performing his or her duties contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to. Now we're going to talk about your rights. You have the right to an attorney, and today Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question your own witnesses, and if they didn't want to appear, the court could issue a subpoena, and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right against self.
Dramatic turn. 3 counts under Michigan's resisting obstructing statute. MCL 750.81D carry real weight up to 2 years in fines per the judge's reading.
Now, how do you wish to plead?
I don't. You said a lot. can I address them part for part?
Plea on your behalf, and here's why.
Can I ask you this first? Can I ask you this first before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading, would have you, I'm sorry, we've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So to plead not guilty, and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider.
Judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. But once again, back to you, Your Honor. From my understanding, I was assaulted. And once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to the situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am Shoulders, Latavius Trayshawn. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am Shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, I let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police. Your Honor, thank you. Mr. Thornton is not a flight risk he has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach, play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community, he is actually beneficial Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people there as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he is.
Bond versus warrant chess, with a 2022 no bond warrant lurking. A simple cash bond here could just ping-pong him to another jail. The judge's cruel to be kind move keeps the case orderly and can credit time served. Fair call or too harsh?
A warrant out of 30th Circuit Court, downtown, East Lansing. Okay.
Yes.
And this is from 2022. And it's a no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you a cash bond on this. You get credit for the days you're in. Then, and we will see you back 8:30 a.m. March 21st. Okay. And probable cause conference, well, or attorney foreman.
Your Honor.
Yes, ma'am.
There was no application. There will be no counsel with him now. If Mr. Thornton changes his mind at any point, he can always apply for the public defender's office. But at this point, I'm unable to submit an application for an attorney.
I would just ask you to consider. But if you don't apply, it can stretch things out a lot longer. And you don't want that. Just worth considering. You make your own decision. You certainly have every right to make your own decision. But I would just, if my beloved baby nephew, who's not a baby, he's about your age,